Namaskar, welcome to my YouTube channel. Myself Professor Satya Prakash, and the topic of today's special lecture is related to the jurisprudence. Today I will discuss about the definition, nature, scope and uses or utility of jurisprudence. Jurisprudence, in the sense and shape in which we understand it in modern time, is considered to be a contribution of the West. Ancient Indian legal thought could not get a smooth course of development, might be due to foreign rule for about 1000 years, and therefore the politico-legal development or philosophical development during the ancient period could not have their smooth passage of time, so that we can have them today also with modern interpretation. In the present times of globalization, every thought, every activity and event has universal application and approach. In these circumstances, study of any branch or subject of knowledge needs to be taken with a perspective of coherence of both local, national and foreign laws. Like many other branches of knowledge, the study of jurisprudence also started among the Romans at the initial stage. If we discuss about the definition and nature, the word jurisprudence is an English term which has been derived from the Latin term jurisprudentia, meaning the science of law. Juris denotes law and prudentia denotes knowledge. In the Oxford English Dictionary, jurisprudence is defined as knowledge or skill in law, the science which treats of human laws, written or unwritten, in general the philosophy of law, a system or body of law. Jurisprudence is a social science which addresses itself to those who study the activity of man in society from the point of view of the legal significance. In the wider sense, jurisprudence is also used sometimes to describe any body of knowledge which has a legal flavor. So, medical jurisprudence, dental jurisprudence, architectural jurisprudence, technological jurisprudence, environmental jurisprudence, criminal jurisprudence, and so on. All these jurisprudence are concerned not with the rules or laws dealing with respective fields, but with the basis of the rules or laws concerning these fields. Though the Romans in practice were never confused about law and morality or religion, but in theory we do not find such restriction in the beginning. Alpine, the great Roman jurist, defined jurisprudence as the knowledge of things divine and human, the science of just and unjust. The another great Roman jurist, Paulus, said that the law is not to be deduced from the rules, but the rule from the law. It was Cicero, another Roman, who defined jurisprudence as the philosophical aspect of the knowledge of law. This definition was nearer truth and the science was progressing well. These definitions and conception of jurisprudence by Roman jurists, howsoever vague, inadequate, or primitive they may be, deserve special credit because they put the idea of a legal science which has an existence independent of the actual institutions of a particular society. It was this beginning which was to assume the present shape of the subject in the course of time. This confusion of law and morality continued for a long time in the continent. According to Salmond, if we use the term science in its widest permissible sense, as including the systematized knowledge of any subject of intellectual inquiry, jurisprudence may be defined as the science of civil law. It is the science as distinct from arts and connotes in its wide sense all those subjects which directly or indirectly treat of the science of law. It is a study not of the law of one particular country but of the general notions or concepts of law itself. Every law is based on certain fundamental principles and those principles are common to all legal systems. Jurisprudence thus confines itself to a systematic and scientific study of the existing rules of law. Therefore, Salmond said that it is the eye of law or the window of law. He also said that jurisprudence is to law or actual legal system as grammar is to a particular language. We must here discuss about the concept of eye of law or window of law given by Salmond. We can very well analyze in view of the importance of eyes in any living being, or whether it is human being or any other creature, that it is the importance of eye that a creature can see everything through eyes. If there is no eyes, then we cannot see the world, and therefore jurisprudence is considered by Salmond as the eye of law, that we look into every aspect of law through jurisprudence. When we talk about window of law, it also brings out the importance of a window in a room or building. Through the window, we can see the whole things outside the house or room. So, in the same sense, jurisprudence is the window of law, and through jurisprudence we can see all the laws and everything related with the human relations. As far as the dictum that jurisprudence is to law or actual legal system as grammar is to particular language. Here also Salmond said about the importance of jurisprudence, that we cannot understand a particular language without knowing about the grammar of that language. In the same sense, we cannot know about the laws without having knowledge of or study of jurisprudence. John Austin, who lived between 1790 and 1859, opened a new era in the field of jurisprudence. He determined the province of jurisprudence. He delivered 6 lectures in 1832 about the nature of law. According to him, the science of jurisprudence is concerned with positive law, with laws strictly so called. The positive law means the law which is given by the sovereign, or in other words, he said that law is the command of sovereign. In technical sense, the law so called means laws set by political superior to political inferior or by private person in pursuance of a legal right. Jurisprudence has nothing to do with the goodness or badness of law. Austin further divided the subject into general and particular jurisprudence. Austin defined jurisprudence as philosophy of positive law or formal analysis of the legal concepts and notions, that is general jurisprudence. So, according to Austin, it is the philosophy of positive law, the law which is given by sovereign, by a superior authority for the guidance and governance of the inferior people or masses or society as a whole. But there must be difference between the lawgiver and the law followers. Holland defined jurisprudence as the formal science of positive law. Science I discussed when I told about the definition of jurisprudence, that it is a systematic or systematized knowledge of a thing of intellectual inquiry. Here Holland added the term formal before science. Formal means that it is a science, a systematic study of the general principles or notions of law in contradiction to the specific laws which are applicable in various countries or nations. Therefore, it deals with the general principles. It deals rather with the various relations of human beings which are regulated by legal rules than with the rules themselves which regulate those relations. Basically, jurisprudence may be defined as relating to the human relations in the society, because law is a social science and basically jurisprudence deals with the human relations. In modern times, the modern writers have expanded the definition of jurisprudence. They agreed that the term jurisprudence does not merely connote a knowledge of law. It covers a field much wider than this. According to Professor C.K. Allen, it is the scientific synthesis of the essential principles of law. The principles of law which are essential in every legal system. Jurisprudence is the scientific synthesis of those principles. It means the synthesis must be scientific or systematic. According to Professor Keaton, it is a study and systematic arrangement of the general principles of law. Understanding the phrase, the general principles of law in its widest sense. Professor Keaton has further expanded the definition of jurisprudence by adding general principles of law. Jurisprudence not only a synthesis of essential principles of law, but it is dealing with the general principles of law, and it is the study and systematic arrangement of general principles of law which are common to every legal system or legal systems of all the countries. According to Gray, the modern writer, jurisprudence is the science of law, the statement and systematic arrangement of the rules followed by the courts and the principles involved in the rules. Justice Gray further expanded and told about the role of courts in the study of the general principles of law and systematic arrangement of the rules. And he insisted upon the role of courts in the proper study and explanation of law under the jurisprudence. As a conclusion, we can say that there may be difference of opinion about the definition, the purpose and scope of jurisprudence, and it is very difficult to give a definition which is acceptable to all. And there may be shortcomings or there may be some positive ideas. In short, we can say that jurisprudence is a study relating to law or a study relating to human relations having legal consequences. Then there we can study classification or branches and kinds of jurisprudence also. Salmon defined jurisprudence as the science of law, rather science of civil law, and by laws he means the law of the land or civil law. In this sense, jurisprudence is of three kinds: expository or systematic, which exposes or analyze or study or the analysis of the existing law, or legal history, which is related with the past development of law, and thirdly, the science of law or the science of legislation, which is related with the future law or how the law is to be progressed or made. These three branches may correspond with the analytical or expository or systematic jurisprudence, historical jurisprudence, which is related with legal history, and ethical jurisprudence, which is related with the science of legislation or what the law should be. A fourth branch is, which is a new development, is sociological jurisprudence. And there, when we say about the scope of jurisprudence, that jurisprudence deals with every aspect of human relations, and generally we say that jurisprudence is not directly related with the laws of some particular or specific country, but there is importance of jurisprudence because through jurisprudence we come to know about the basic precepts, basic norms or basic principles upon which the laws, particular or specific laws of various countries are based. As far as scope and uses of jurisprudence are concerned, jurisprudence tells about the nature of law, which we study under various schools of jurisprudence, which we call legal theory. There are basically 7 schools of jurisprudence. When there are different opinions about the nature of a particular subject, then the similar opinions are grouped under one approach, and these are called the approaches of that particular discipline or the schools of that particular discipline. So we call them schools of jurisprudence. The first school is analytical school or analytical positivism, which was propounded by John Austin. The second we study is the pure theory of law, propounded by Kelson. Then we have historical school. Under historical school, we study Savny, who gave the doctrine of Volksgist, and we study Sir Henry Maine, who is also considered to be propounder of anthropological approach to the study of law. Then the fourth approach is economic approach, given by Karl Marx and Friedrich Engels. The fifth is sociological school, under which we study 4 different aspects. First is social origin of laws and legal institutions. The second is the task of laws. The social origin of laws and legal institution is given by hearing. Under the second category, that is task of law, we study Jeremy Bentham, having the doctrine of utility, or the other thinker is Dean Roscoe Pound, who gave the doctrine of social engineering. The sixth approach is known as modern realism, under which we study the American realist and Scandinavian realist. The seventh approach is natural law theories. Under natural law theory, we study in four periods: the ancient period, which is included under Greek period and Roman period; the medieval period; the third is Renaissance; the fourth is modern natural law theories. If we then, under jurisprudence, after legal theory or schools of jurisprudence, we study administration of justice. Under this head, we have administration of civil justice and administration of criminal justice. And from jurisprudential point of view, the theories of punishment, the purpose of punishment, which are generally known as theories of punishment, are studied. Then we study sources of law. Basically, there are 3 sources: custom, precedent, and legislation. Then the other part under jurisprudence is related with the concept of law or elements of law. Under this, we study concept of rights and duties, person, possession, ownership, liberty, property, and sovereignty. As far as uses or utility of jurisprudence is concerned, we can say that it provides an understanding of the nature of law. Secondly, it helps in the study of the actual rules of law and in tracing out principles underlying these rules or laws. It helps in making a scientific development of law. It develops the critical faculties of the mind and gives the people proper understanding of legal expressions and terminologies. Basically, there are three organs of state: legislature, executive, and judiciary. It helps the legislators to understand the nature of law and to have proper and expanded view of the laws to be made by the legislature, taking into consideration the background of that particular problem to which they want to make some law. For executive also, jurisprudence is important to know about the actual nature of law and to what extent they should work to implement or execute law. For judges, the study of jurisprudence is very important because they can know about the general nature of the principles of law, the doctrines of law, along with the substantive or procedural law of a particular country or state. In this lecture, I would like to refer to W. Friedman. He said, "A crisis of society challenges the law directly. This is the importance of law. If we have some crisis in the society, it is the direct challenge to the law, because law is to govern the society. We call it rule of law. All the activities, relations of the state organs as well as the individual are to be regulated by law, and if there is any crisis in the society, it means there is something lacking in the rule of law. Therefore, it directly challenges the law." Martin Luther King Jr. said, "Injustice anywhere is a threat to justice everywhere." The point is that whenever there is a breach of law, we should not ignore it or overlook it. We should care every breach of law and provide redress. Otherwise, it will become wider and there would be losses or injustice to the others also, or ultimately to the whole society. So, with these words, I end this lecture on introductory aspect of jurisprudence In my forthcoming lectures, I would discuss about topics which I refer today under the scope of jurisprudence. Means that first I will take up the various schools, starting with the analytical positivism or the school propounded by John Austin. Then I will take up the administration of justice, then sources of law, and then the concepts or elements of law. Thank you very much and all the best.